So after this quick break, we are now back again here with the next presentation. This presentation is about insights into witness examination, and it will be by Stefanie Pfisterer and Andrew Meerwarth. Stefanie Pfisterer is a member of the SCAI Arbitration Court and partner with Homburger, a major Swiss law firm. Andrew Meerwarth is an associate with Weil, Gotshal and Manges in New York. They will give us some first-hand insights into the art of witness examination, and other aspect of arbitration we don't usually get to see in the moot. And now we can maybe see behind what would happen if we have a hearing on the witness examination and the experts in this case. And with that, I will now hand over to Stefanie Pfisterer and Andrew Meerwarth.
Thank you very much, Jeremias. Good afternoon, everybody, or good morning, everybody. It's certainly a good morning for Andy Meerwarth, who had to get up early this morning, this Saturday. As Jeremias just mentioned, we would like to introduce now the topic of cross-examination. Being a mooty, you are of course familiar with how to draft briefs, and you are familiar with how to plead, or how to do opening statements, as we would call them. Now we would like to show you a topic with which you are probably less familiar, and that is cross-examination. We have picked as a witness where we would like to demonstrate such cross-examination, we have picked Mr. Dorty, who is a witness for a respondent in this arbitration. We will do a short introduction into the topic of examination and cross-examination of witnesses, and then we will demonstrate a short cross-examination. So how are witnesses introduced into an arbitration? Typically, a party that wants to present a witness will file a witness statement of such witness. This is what we also have here in the moot file. We have the witness statement of Mr. Dorty on file. Typically, the witness statement that serves as direct evidence. So that means the party who offers the witness explains what the witness will tell to the tribunal in that written witness evidence. So it's basically for the other party here, the claimant, to then cross-examine the witness. Before the hearing, each party will usually pick and decide which of the other party's witnesses it would like to hear at the hearing. So now here, let's assume that the claimant would have said, I want to cross-examine Mr. Dorty and I want him to appear at the hearing. Then the hearing will proceed with the opening statements, basically the pleadings you are now doing, and then the witnesses will be examined. So let's assume Mr. Dorty, he will then come into the room or enter the remote hearing and take the witness seat. Then usually it will be for the party who presents or who offers the witness to do a short direct examination. I just mentioned that the witness statement basically serves as direct examination, but usually the party bringing the witness can still ask a few questions at the hearing. That serves the purpose of making the witness comfortable and also address with him a few important issues. Thereafter, it is for the other party to do the cross-examination. Andy, would you like to say a few words about how cross-examination works?
Of course. Thank you, Stefanie. And thank you, Jeremias, for the very kind introduction. So what is the aim of cross-examination? There's really going to be two primary goals here. One is to elucidate facts, to get facts out of the witness that are going to support your party's position in the arbitration. The other very important aim, and perhaps the more important aim on a cross-examination, since most of the facts supporting your story should hopefully come from the witnesses you're introducing. Really the primary goal of the cross-examination is going to be showing the tribunal that the position of the other party is not credible, and sometimes that their witness is not credible at all. And you can sort of accomplish this by trying to get them into a position where they're contradicting earlier parts of their testimony, contradicting things that they've said in their witness statement, etc. So how do you do that? The goal is going to be to really ask very narrowly worded questions. What you don't want to do, you don't want to give the witness an opportunity to sort of, tell us your story, elaborate, go ahead and explain, why do you think this happened? That's not what you want. You don't want them up there on the witness stand just sort of explaining. They'll come up with a justification for anything, a reason to see things their way. So stay away from that. What you want to do is ask them very narrow questions and sort of phrase things like, is it correct that, and then state the facts the way that your party understands them. Is it correct that such and such is true? And then either they're going to have to, they're in a very narrow position where they either have to contradict exactly what you're saying, and if you're phrasing things in an accurate way, it's going to be hard for them to contradict what you're saying without perjuring themselves. So you really want to box them in. In practice, you're going to find different styles. There's different styles of cross-examination. You can be very aggressive. You can be very kind and try to be friendly to get the story out of, to get the facts out of the witness. And different styles, the tribunal may react differently to different styles, just as in your oral arguments. Some of you have probably already received feedback by now that the tribunal thinks, oh, you were a little bit arrogant when you said this, or, oh, you need to, be a little more aggressive when you say this. It's the same thing with cross-examination. The tribunal will react differently to different styles. So you're going to want to sort of adjust your style based on the tribunal, but also on the witness, because some witnesses, if you're super aggressive, they'll just start spilling their story. Other witnesses, if you're aggressive, they're just going to clam right up like a turtle. So you don't want to be aggressive. So you kind of got to read the room, read your witness, and figure out how to talk to them and get them to speak in a way that's not going to make the tribunal displeased. So I think that's what you need to know. Back to you, Stefanie.
Thanks a lot, Andy. So we will now proceed to the cross-examination or examination of Mr. Dorty, and Andy has agreed to be Mr. Dorty for that. Before the cross-examination, when the witness then takes the seat, the tribunal will usually admonish the witness. And why do I say admonish? The reason is that giving false testimony is usually a criminal act, qualifies as perjury in many countries. So the tribunal often asks witnesses to read or repeat an admonishment, and we will show that to you as well. So if I were the tribunal, I would then ask Mr. Dorty to please read the admonishment. Mr. Dorty, good afternoon. Could you please read the admonishment that you have in front of you?
I understand. I have been requested to appear today before an arbitral tribunal as a witness in an SCAI arbitration between Respivac PLC as claimant versus Cambir Limited and Vectorwear Limited as respondents. I hereby confirm that where I state facts, these are in my written witness statement or in my oral testimony, they are within my own knowledge and they are correct and complete. And where I state my opinion, they represent my true and complete opinion. Further, I am aware that I have to tell the truth to this arbitral tribunal. Any failure to comply with this duty could lead to private law sanctions, for instance, damages, and even criminal prosecutions. Should I refuse to testify in this arbitration, I may be summoned by a state court and required to testify before it.
Thank you. But after that, we would have, as I mentioned, a brief direct examination, and we'll skip that for today and we'll proceed to cross-examination right away. So for that, I'll be now the claimant's counsel. Good morning, Mr. Dorty. My name is Stefanie Pfisterer. I'm counsel for claimant in this arbitration, and I'll be asking you a few questions today.
Morning.
Mr. Dorty, you were born in 1961, is that correct?
That's what my mother tells me.
You have a law degree, Mr. Dorty?
Yeah, I went to the law school at the University of Notre Dame.
So you're a lawyer today, right?
Today and every day, yes.
Specifically, you're the head of the contracting department at Cambir Limited, one of the respondents here, is that correct?
Yes, yep. I have been employed there since January 1st, 2019.
And prior to that, you have been the director of legal at Vectorwear, right?
Yes, I handled a variety of legal issues at Vectorwear.
You were the director of legal at Vectorwear, correct?
Yes, that was my title, yes.
Have you participated in an arbitration before?
Yes, yep.
Mr. Dorty, you have signed and provided the written witness statement that is dated August 10, 2020. Did you personally prepare that witness statement?
I don't remember the exact date of the, I prepared a witness statement. I don't remember if it may have been August 10th, yeah.
The witness statement we have in front of us here, that is dated August 10, 2020. Can you confirm that this is your witness statement?
Oh, yeah, yes, yep, of course. Yes, this is mine.
Thank you. Did anyone help to prepare you the witness statement?
No, no.
Did the lawyers of respondent help you to draft the witness statement?
I am a lawyer. I don't need the help of other lawyers to do something like that.
So you drafted it on your own?
Yes, correct.
Mr. Dorty, are you receiving any compensation for being a witness here today?
No, I am not. However, I am obviously currently an employee of Cambir, one of the parties here. So.
And is your salary at Cambir in any way connected to the arbitration or to a success in the arbitration?
No.
Mr. Dorty, you're familiar, I assume, with the purchase collaboration licensing agreement between claimant and respondent, right?
Yes, of course. I negotiated it.
Yeah. We had provided a copy of that agreement today for your cross-examination. Do you have that agreement in front of you, Mr. Dorty?
Right here.
Excellent, thank you very much. You say you negotiated the agreement, but isn't it correct that these negotiations actually began with your predecessor?
Yes, that's true. However, he became ill. I took over the negotiations, I believe, in December 2018.
So December 2018, that was the time when you were still working for Vectorwear, correct?
Well, I was working for Cambir, but technically, officially, I was, still a employee of Vectorwear.
When your predecessor was negotiating the agreement, the draft that was based on a model contract he had used for, or Cambir had used for manufacturing contracts. Is that correct?
As I recall, yes.
And then when you took over, you used a different model, right?
Yes, well, Respavac had made it very clear they did not think that the model my predecessor was using was going to, it wasn't going to work for them. They did not think that that model of contract was appropriate for this kind of research and development transaction. So yes, I introduced an alternate template that we ended up working from.
So you said you introduced an alternate template. What was that template based on? Do you recall that?
That was the agreement we had entered previously with Ross Pharma.
And was that template changed when you had then used it for the agreement with claimant?
Yes, of course. There were many changes throughout. Many of those were minor.
So you say the changes to the agreement to the draft were minor. Is that correct?
Well, to be clear, we introduced a new Article 16, which in some respects was a significant change to the agreement. But yes, for the most part, the changes were minor.
So apart from Article 16, you can't recall any significant changes, right?
Correct.
Thank you. Mr. Dorty, I would like to ask you now a few questions about Article 14 of the agreement with claimant. Are you familiar with that provision?
I can't recall off the top of my head what Article 14 was.
Can you please refer to the agreement and refresh your mind, please?
Oh, of course. Yeah, of course. Sorry, it's the dispute resolution. Why we're here today.
Exactly. Thank you. So Article 14, Mr. Dorty, was that a new addition to the agreement, or was that taken over from the model?
That was taken. That was part of the agreement we entered with Ross. That was accepted from the model. Correct.
So when you had taken over that provision, do you recall having negotiated that provision with the claimant for the new agreement?
I don't recall negotiating over that provision, no.
So the provision was accepted from the template?
As I recall.
And do you recall how that provision came into the agreement with Ross? The template, as you refer to it?
It's very similar to the model dispute resolution clause that is in the Swiss rules proposed for parties to use.
Very similar, but not exactly the same. So did you negotiate that provision with Ross?
Yes, we did.
Did Ross object to your first draft of this provision?
In one respect, particularly as I recall, yes. So initially, I had proposed a documents only arbitration, and yeah, Ross was made it very clear that was not going to work for them. They objected. They persisted that an oral hearing was absolutely necessary to them. It was very important to them. And I had to redraft the clause, and I think the clause as written today reflects that concern of theirs.
And in what way does it reflect their concern?
Well, the clause as written requires that, if I can read here, the hearing shall be held at the tribunal's discretion, either in Vindobona or in the city where the respondent has its place of business.
Thank you. Mr. Dorty, when you negotiated the agreement with claimant, was the issue of in-person hearings discussed?
No, as I said, claimant accepted the provision from the Ross agreement as we already had it written.
Was it discussed with Ross during your negotiations whether a hearing need to be in person?
Yes, as I said, they strongly objected to a documents only arbitration. They insisted on an in-person hearing.
Mr. Dorty, before you said that Ross objected to a documents only arbitration and wanted to have an oral hearing, but now you say Ross wanted an in-person hearing. Did you in fact discuss the topic of an in-person hearing with Ross?
Yes, they wanted an oral hearing. They insisted, well, initially they insisted it had to be in Danubia. We later changed, so now under the present clause, the tribunal had discretion under 2 different locations, but they insisted in person at a location.
Mr. Dorty, do you understand the difference between an oral hearing and an in-person hearing?
When the contract says the location where the hearing must take place and that it has to be an oral hearing, then obviously that oral hearing, if it's at a location, it must be in person.
Mr. Dorty, you're not here as a legal expert or as counsel. You don't have to advocate the position of your parties. I'm asking here a question. You're here as a fact witness, and I'm asking a question about your recollection. So let me ask a different question. Did you negotiate with Ross the topic of remote hearings?
No, we did not. No, I do not recall discussing that.
So the only reason that Ross insisted on an oral hearing is because they objected to documents only arbitration, correct?
Yes, that is correct.
Thank you, Mr. Dorty. I have no further questions for you. Okay, that was the short demonstration of cross-examination. And before we head to the next round, we thought that it would be good to have, if both of us, myself and Andy, comment quickly on how we were asking questions or providing answers. Maybe I can start. So what you may have realized is that most of the time I asked very focused questions, as Andy had mentioned in the beginning, that only call for a rather yes or no answer, and above all also questions where I had known the answer beforehand, so that I could confront then also the witness with documents if he had not given the correct answers. I started off with a few questions on the drafting of the witness statement, whether he had any assistance with that, whether he's being paid for his role as witness. That can be done to make the witness feel a bit uncomfortable. And then I started off with that, with these questions about the negotiations of the contract and his still employment for the former, for the respondent 2, and then he's changed to the respondent 1. This is often done, you know, sort of these questions where you already know the answers are often done to make the witness aware. I have a counsel that is questioning me that that knows the facts, and if I'm not giving the correct answer, I'll be confronted with the document and I'll be proven wrong. So I'd better do a good job here. And do you want to say a few words about how you had given answers and how it felt being a witness?
Yeah, I'll just say a couple comments. So I actually realized in our intro, we talked about doing a cross, but we didn't talk about sort of, and there's also a defense aspect for the party whose witness is being crossed. So there's a couple things. First of all, a witness, you're going to have to be careful when you're giving answers, because you don't want to state things too strongly, because if you give a really strong characterization to something, it might be a really good cross-examiner. Like Stefanie is incredibly smart, very good at this. She's going to get you in. The stronger your characterizations are, she's going to get you into a corner, and she's going to really show that you're just saying what you want to say. You're not really sticking to the facts. You're not doing a good job as a fact witness. So you want to be careful. And a really crucial part of that is going to be in line with ethical guidelines of practice. You've got to prepare your witnesses, and a big part of that's going to be just sort of practice with them. And for example, do a mock interview like this, a mock cross, just to put the witness under the gun a little bit, see how they're going to react when they get asked some tough questions. So you just want to help prep them before they go under the gun with someone like Stefanie.
Good. And so to conclude, maybe let's put a bit into context what I, as the cross-examiner, have tried to achieve, especially with these last questions about the hearing that are of course a relevant question to the moot arbitrations. So what I've tried to get from Mr. Dorty is that in fact the question of in-person hearing has never been discussed, but rather the reason why we have that Article 14 in the contract is merely because Ross at the time had objected to a documents-only arbitration. And normally after the hearing, the parties would then file their post-hearing briefs where you can discuss the evidence that has been obtained at the hearing, and then you would normally show to the tribunal that the witnesses you have cross-examined now prove that your case is indeed the correct one.
I think it's a bit of a minor win. Obviously it's not a confession that wins the whole case. And I think in practice, you'll often find that the admissions you get are going to be even smaller than that. So it's going to be it's a slow, arduous process of building up with little blocks of, you try to get an admission on this, you ruin their credibility on another issue. So it's just like a slow building and tearing down process of trying to get your case. And that's where that post-hearing brief really comes in handy, because you've got to put all the pieces together for the judge. And this is what they admitted. This is what we show that they're not credible on.
Absolutely. Thanks a lot, Andy. I believe with that, we hand over the floor again to the organizers to proceed then to the next round.
Thank you, Stefanie.
Thanks a lot.
So exactly. So thank you very much for this very insightful presentation on an aspect we don't usually get to see at the Pre-Moot, and also on the ideas of how this could now proceed in the next rounds when there actually will be these hearings. So thank you very much for that part.